The only person who can evict you is a judge, not your landlord. While your landlord may tell you they are evicting you and may file the legal paperwork to get the process started, it is ultimately up to the judge to decide whether or not you are being evicted, and it is up to the agents of the court, the sheriff and the bailiff, to carry out that eviction. If, without the approval of a judge, your landlord changes your locks or forces you and your belongings out onto the street, that is illegal, and you have options. Understanding how a legal eviction process works is the first step to protecting yourself and your community from illegal evictions. So today, we're going to break down that process for you. However, it is still important to note that even if a legal eviction does get approved by a judge, the tenants union will still work with you to find a way to keep a roof over your head. So do not give up hope. My name is Aiden, and I am with the Lansing Tenants Union. Listen, I get it. The legal system is stressful. It makes my brain hurt. It makes me want to drink pre-mixed margarita straight out of the bottle. But you can make the red tape work for you. Eviction is procedural. If your landlord misses a step in that process or messes a step up, that gives you a stronger defense against the eviction in court. This bureaucratic back and forth can keep you in your home for days, weeks, or even months. Stage 1. You receive your first notice. This can be a 7-day notice for non-payment of rent or a 30-day notice for some other lease violation, like smoking in a non-smoking unit. Usually those 7 or 30 days are the time you have to fix the problem, so usually to come up with the rent. After that time is up, then the landlord must go to court and file an eviction case. When your landlord gives you a notice to quit, they might tell you you're being evicted, and that you need to vacate the unit within that 7 to 30 day period. But a notice to quit is not an eviction, and you do not need to vacate your unit. You cannot be evicted without a court order. Cannot be evicted without a court order! Cannot be evicted without a court order! If your landlord is telling you to move out, they're probably trying to make you do what's called self-evict. Self-evicting is when you move out despite not being asked to by the court. If your landlord can scare you into moving out on your own, they get to skip the hassle of actually having to go through the legal process. You cannot legally be evicted without a court order. Illegally, I mean, like, landlords get up to all sorts of funky shit, but legally, cannot be evicted without a court hearing. If you didn't actually ever receive a notice to quit, but the landlord's trying to push through a court date, that might be grounds to delay or even throw out the eviction. In stage 2 of this process, you're looking for 2 pieces of paper. The first is the complaint. What does the landlord want? The landlord can ask for both money and possession of the unit in the same case. Make sure to check if they are asking for money as well as possession by looking at the bottom of the complaint to see if they have filled out a supplemental complaint. If that is filled out, your landlord is also seeking money. Second is a summons to court. When and where is your court date? Look for the location and date and make sure to pay attention, because if you do not show up to your court date, the landlord wins by default. Okay, that's great, but how do I know if I have a court case against me? If you're catching up, don't know if your landlord has filed a case, or don't know what has been filed against you, what you need to do is look up your case. There are a few different courthouses in the greater Lansing area. 54A is Lansing, 54B is East Lansing, and 55 is Mason, and Ingham County covers the entire county. We included the contact information for each court in the description of this video, as well as online tools you can use to help locate your records. You can also call the courts, or if you can, show up in person, and the clerk can help you locate your records. Okay, I looked, but I couldn't find a record on any of those sites, and the clerk couldn't find it. Be thorough. Make sure to try different names, every name that you have ever used, as well as the address you're currently living at. And if there are no records, that is great news. It means you're back at step 1. If your landlord threatens you or otherwise tries to evict you without filing the paperwork, they are in the legal wrong. Okay, I found a record and there's a date. Whatever you do, show up to court for your court date. At the time of this recording, most of these hearings are being held via Zoom due to the pandemic, but that may change by the time you watch this. Contact Legal Services of South Central Michigan immediately and contact the Lansing Tenants Union for support. You can usually file for an extension of about a week to get your defense figured out, but you must show up to do so. If you do not, you get what's called a default judgment. What is a default judgment? Oof, okay, this is the worst case. That means that your court date already happened and you were not there and the landlord won by default. Call Legal Services of South Central Michigan immediately. You may have the chance to reverse the default, but it is unlikely. Worst case scenario, you could be evicted at any time. Best case, you can delay the eviction and maybe even reopen the case. Okay, so it's your court date. What do you need to do? Well, show up on time and be presentable and polite. Remember, everybody hates court. You, me, remember the margarita? We did the whole thing. You can negotiate with the landlord and their lawyer. Usually the landlord just wants to be paid anyways, and you might be able to work out a different payment plan for rent or something along those lines. Your landlord is going to file either a notice to quit or a demand for possession. If you have received either of those from them, contact the Eviction Defense Hotline, Legal Services of South Central Michigan, and the MSU Housing Clinic immediately. If you lose by default or in court, you usually still have 10 days to pay or fix the issues or vacate the home. After those 10 days, and only after completing all of those steps, your landlord must still file for a writ of restitution. Only once a writ of restitution has been signed off from a judge, only then is the landlord allowed to forcefully change the locks and put you and your belongings out onto the street. Except your fight still does not have to be over because the Lansing Tenants Union is here to support you. If you're being threatened with eviction, contact the Lansing Eviction Defense Hotline at 517-234-8613 or email us at lansingtenants@gmail.com. Every tenant is unique, every situation is unique, so there's no one-size-fits-all solution for eviction. Contact us and we will be able to work with you to keep a roof over your head.